Welcome to the law. Let's start our meeting with a word of prayer. Dear Lord, we praise you and thank you for this day you've made, the many blessings you bestowed upon us in our lives. We ask that you watch over our families and our friends, that you give them good health, happiness, and peace. Guide our actions. Lord, help us to be your servant people here on earth to make this world a better place for all people. In Christ's name we pray. Amen. Announcements?
Our speaker next week is Tanner Short, who is our intern from, I believe, Columbia Theological Seminary. He's working with our youth, and so we're going to hear his story next week.
Eddie, would you like to introduce your brother?
This is my first cousin,
Sorry.
Bert Garland. He is a retired lawyer, born and raised in Jackson, Georgia. His dad was my father's brother. Bert had three brothers. One was a lawyer, and one was a professor at SUNY. And they all grew up in Jackson. And Bert has 4 kids, 5 grandkids, and they're all around the country. And it's a dear friend of mine, with the 2 last standing in that generation.
In case you wonder where I got my name, I was born Bruce Garland, and my uncle Reuben came to the hospital here in Island Piedmont and said, he's not a Bruce, he's a Bird. And his dad, James J. Garland, was nicknamed Bird, B-I-R-D. So what they did, they bastardized the name, so I went B-I-R-D. So I became Bird Garland, and go home, later on, the governor, the lieutenant governor was Garland Bird. But I was in law school at Mercer. I had no trouble at all, cashing checks anywhere in town. So.
Anybody else have anything to say for the good of the friend? Our speaker today is very special because she agreed to our speaker. I really appreciate it, Libby. Libby attended Westminster, and she got married to John in 2001 at First Presbyterian. She grew up in a church that no longer exists, called Peachtree Presbyterian Church. She attended First Presbyterian and served on the session from 2013 to 2016 there. She joined our church in March of 2023. Very quickly became a prominent player here. She and John, which she is on the adult education.
He's taught.
All right, so Libby joined the adult education committee in May of 2024. Right. And last Sunday, she was installed as an elder at Trinity Presbyterian Church, her first term here. She is a lawyer, and she did private practice for a while, and then she became a staff attorney for a superior court judge who has a very interesting history. Cynthia Wright. Cynthia was in the domestic court, and they separated.
She was governor's counsel for Saul Miller. He was governor, and then she did family division for a long time, and then moved out of it, just
We can hear more about your career, that very few things to say there. But she worked with Cynthia Wright in the superior court, which is the trial court system for those non-lawyers in the crowd. And then for the last 10 years, she's worked with Sean Ellen LaGrua. I've appeared before Cynthia Wright, before Sean Ellen LaGrua over the years. These are 2 very good judges, very good grades judges around. And Judge LaGrua is a Supreme Court justice here in Georgia. So as the staff attorney, she considers the issues that come to the Supreme Court and has input on the most important issues, the highest level law issues that goes to the courts of our state. So, Libby, I'll ask you to correct anything I just said.
Right.
Please join me in welcoming Libby.
Good morning.
Good
Can you
morning.
all hear me okay?
Yep.
Everybody on Zoom hear me okay? I'm really, I'm honored to be here. Thank you for having me. I hope it will not bore you. I hope it will be interesting. So, as Jim said, I am a staff attorney to Sean Alubura, who is one of 9 justices on the Georgia Supreme Court. How many lawyers were in? Oh, okay, yes.
Too many.
How many have appeared before our Supreme Court? For goodness? How many within the last 7-8 years? Maybe. So, the current group on our, so we have 9, used to be 7. We have, the like longest ranking justice we have has only been there since 2016. So it's a very new group of judges. That justice, Justice Nels Peterson, is our Chief Justice. And the Chief Justice is generally the most senior judge. So just that's generally how it goes. Sometimes they may go out of order if there's someone who is going to retire that has never had an opportunity to be the Chief Justice. They will, someone that the highest ranking might step aside and let them have an opportunity to serve in that capacity. With our current group, it's been here long enough to have that problem. So we've just, there's been a lot more turnover. Justice Peterson, this is an interesting tidbit. If you don't know, you probably don't. He was, he created the role of Solicitor General for the Attorney General's office, and in representing the state, often in form of the United States, the Georgia Supreme Court. And he served in that role, after which he was appointed to the Georgia Court of Appeals. The next 2 Solicitor Generals who followed him, Sarah Warren and then Andrew Pinson, both are now on our court. So the last 3 Solicitor Generals have all been later appointed to the Georgia. So you can imagine that the current Solicitor General, who looks like he's about 15, he is probably thinking, hey, who's my Jake? So, but we have everyone on our court that's currently serving is appointed by the government, by a Republican government, with the exception of Justice John Allen. And he ran for a seat unopposed. So, he came in without any issue. Of course, once they're appointed, every 6 years they have to run. So they've all been appointed, but they've all also run for re-election. As you can probably guess, having been to the voting booth, a lot of our judges, justices, and judges in the trial level, if they're incumbent, they often slide there. People just don't really know much about judges, so they usually just vote for whoever they need. Our justices have varied backgrounds, varied experiences. My justice, Sean Alubura, was a prosecutor, career prosecutor. She briefly worked for the Secretary of State as the Inspector General, and then she was appointed to the Fulton County Superior Court in 2010. We have 3 other justices. We had Justice Fox, but the others, he's since retired, that have trial court experience. You can believe that. There are only 4 of them total right now on the court that have ever served as a trial judge. So my judge, I feel very passionately about her experience because at the end of the day, our court is writing for trial judges. They're the ones who are reading these decisions that we issue. They're the ones who are bound by them. They're the ones who have to process them and try to make decisions. And so the current makeup of our court is interesting for those justices and judges below us who are trying to interpret the law that's in front of them. And I'm going to say a little bit more about that. I am one of 2 staff attorneys, so each one of our 9 justices has 2 staff attorneys full time. And then we also have a term who's a recent law school grad, it looks a little bit like the federal model. Federal courts usually have 2 full-time staff attorneys and then a law clerk who works for them for about a year. We have the same thing though. And it's great because they're young and you can give them research assignments and they'll dive right in. My justice tends to like someone with a little bit of experience. A lot of them have come from the federal clerkship before they come to us. And that tends to just work better for her. But some of them prefer to have someone just right out of law school, right out of. Talking a little bit about federal versus state court. The federal court system and our state court system are similar. One striking difference is, of course, that federal judges are appointed for life. So they get appointed at the trial level, the appellate level, or the United States Supreme Court, they are life. So unless they take themselves out of the game, they're there for life. So with obviously state court judges, they're life. So, trial judges are in the state court level of the superior. So every county has a superior court. Some of them also have a state court, which is usually dealing more with like misdemeanors, things like that. Fulton County is where I actually worked for 11 years before I came to the Supreme Court. And I've been on the Supreme Court now for 4.5 years. So I worked with Cynthia Wright, as Jim said. She was on the Superior Court of Fulton County. How many people live in Fulton? How many people live in jury duty in Fulton County? Anybody? So it's really conveniently located to where you live and work. So it's always interesting when we used to have juries and I always felt especially bad when we would have like a mother who's literally scrambling to get some of the kids to school and then she's schlepping down on MARTA, to get down to the courthouse. It's terrifying, I think, for some people. It's not the place really any of us ever have cause to with. So I was there with Cynthia Wright for 5 years and then with Judge for until she was appointed to the Supreme Court in 2021. So she came on in the midst of COVID. There was nobody hardly in our courthouse. So we have a brand new building. Remember where the archives used to be? So now if you go down at Memorial and Central, you're on I-20, you'll see there's a brand new building that they built for the Court of Appeals, the Georgia Supreme Court, and we also have a statewide business court now, which is, I don't know how much business they have, but it's a court that's was established to help basically deal with complex business disputes. They try to put somebody in there to specialize in that, it's something the voters voted for. Probably another instance of going to vote and saying, I have no idea what this is. So anyway, but it's a court that's also in our building. So they built this brand new building for us. It's completed at the end of 2020, and of course we're in the midst of it. So my judge came in. We were one of the only chambers who actually had everybody quiet. Like you just walk around and it was us and the cleaning staff, and we would see other people there really. And our first few meetings were all by Zoom, and the first few oral arguments were by Zoom as well. And so it was a fascinating time. Of course, that has changed. We'll come back up. So the types of cases that we see in our court, this always surprises people. The majority of the cases we have are murder cases. I would say 97, 98% of the cases that we review in the Supreme Court are murders. And the rest of them are constitutional question, if it's something we've never addressed, and if the lower court has actually ruled on the constitutional question. And then the remainder are what we call granted certs. So it's a question that case is on before Court of Appeals, it's been appealed up. The parties are saying, the Court of Appeals got it wrong, we would like for you to address it, or the Court of Appeals applied the law in the wrong way, whatever might have happened. So they will then ask for our court to review. Now that is how most Supreme Courts operate, to include the United States. So most cases, most Supreme Courts across the nation have just general cert jurisdiction. And that's just, they select which cases they're gonna take. We don't have them. We have a direct appeal of all murder cases. And then we have some discretion with respect to the constitutional questions and the service. And, so in large part, what happens in our court is, the way the state's court operates, you've got state superior courts all over the state, through probably just about every state. Then one court of appeals, and then one state supreme court. You can seek to appeal the case from us to the United States. That has happened a couple of times with our cases. The Supreme Court has actually granted cert on that. So with murder cases or any case, it's docketed, it's assigned to one of the 9 justices. And sometimes they have to be disqualified or they don't participate, maybe they have a spouse who's gonna be arguing the case. Or in the case of my judge, she might have been the trial or been involved at some point, especially because we see so many murders. So during the time I've been, just the 4.5 years, I think she's had to disqualify from at least 5. Because at some point along the line, she was involved in a trial. And so once it's assigned internally, so one of the 2 staff attorneys will get, so in our case, it's like even odd. You know, and an even case gets docketed to us, and that's just, it's an internal number, it's mine to work on. And if it's the other, it's my co-staff attorney. So at that point, we have to start reviewing the record. With murder case, you're talking about reviewing the entire trial transcript and all the evidence. And so it's very time consuming. And I'm very grateful because my judge actually was a prosecutor and a trial judge. So when she reads a trial transcript, she knows what she's looking at. The other justices that have not had trial experience, I would say have certainly learned the process, but I would tell you right now, some of them have never sat there. Never seen that firsthand. So there are times where the nuance of what happens in a trial might be a little lost on. You know, if you've been in court a lot, how many of you have been in court a lot? So you know, you start to know, you know, this is what happens in a jury trial when the judge says this. You know, there's things that happen that you could read into a transcript when you have experience with it, that if you've never seen it, you might either overinflate or under, you know, sort of kind of diminish how important it really is, you know. And so it's fascinating. It's fascinating to read. But it's very lengthy because what has to happen next is, as a staff attorney, we prepare for our justices a brief that summarizes everything so that they know, because they do not have time or the ability to go through and read it. Now, in a granted cert case, and I'll give you some examples of those in a minute, you know, that's easier. You've got a record, you've got the Court of Appeals decision. You're not usually talking about it, you're not looking at the trial transcript in large part. But with a murder, because we have direct appeal rights, so what happens with murders, and actually any criminal conviction in the state of Florida, when you are convicted of a crime in jury, you have an automatic right to file a motion for a new trial. Then you have a right of appeal, and you also have a right to file habeas. So that is something, there are many opportunities to have your case reviewed, which I think is good. One interesting fact about murders, we do not see as many death penalties. And I actually learned from watching a West Wing episode the other time. And I knew this, but I wasn't sure about the timing. So I know that's gonna hurt you. Did any of you think that there was any point in time when we would get the death penalty in the stage? Raise your hand if you think we would. Yeah, gave death penalty to a juvenile. So would it interest you to know that did not change? You were right. Yes, we did used to give death penalty to juveniles who were convicted of murder. That did not change until 2005. Very recent. 2005, and that's because the United States Supreme Court came out with a decision that said cannot give a death penalty to juveniles. The other thing that's changed in our state is that we used to not have life without parole. It was only life with parole, with the option. So more than often than not, you might see, there might be a case where they would seek the death penalty because they don't want this particular individual to see the light of day. Once we came out with life without parole, we don't see the death penalties on, we don't get as many death penalties. But in our parole, we have one full-time staff attorney who is just focused on death penalty cases. And that is because, rightly so, there are so many motions and things to go through that happen at the trial court level before someone is given a death penalty. There's so much information, so much to go through that they have, it would be impossible for judges, our justices in addition to the staff firms with everything else going on, to also have to review that on top of it. So what happens, as I was saying, we review a docket, and then what we'll do is we have what's called bank. Bank, we meet every couple of weeks. And it's a time when the justices hear about the cases that they have assigned to them. If we have opinions circulating, that's the time they'll review them. But the first step in any case, is what's called, it's a submit group. And it basically summarizes the facts. In a criminal case, those are extensive, depending on what's at issue. Because it just depends on what the appellant is raising on appeal. A lot of times they like to raise an ineffective assistance of counsel point, which means my trial counsel. And this is a really hard one because at the time that they're convicted, the time they file their motion for new trial, they have a certain time frame within which they have to do that. And so a lot of times you have the trial counsel who's filing that on their behalf, who may also be saying, I was ineffective. Which is, I didn't do my job well, which feels completely, just out, I mean, that doesn't make any sense. But it happens, and then they usually will retain a public counsel. And a public counsel will usually file something more expensive, because at that point, they actually have access to the record. They'll have reviewed everything, so at that point, you'll get something that's much more detailed, and that's what comes up on it. Often they raise most motions for new trial, this will not surprise you, often it's the same trial judge hearing the motion for new trial, presided over the trial. And so when you're saying there's trial court error to doing X, Y, Z, my attorney was ineffective, when the trial court looks at that, they're saying, I don't see it. I mean, that's often what happens. But every defendant, I mean, I'm sure there are some that do not, but they all file a motion. So it's not something that just a few will do. Any defendant in large part who's convicted will file a motion. Because why would, I think that's just a mindset. But so there can be cases where what they're alleging feels very tenuous. But then there are definitely cases where what they're raising is extremely valid. And while we often affirm, we have definitely had cases where we reverse. I'm going to talk about one of those cases. This is the case where I learned about the death penalty for the juvenile. So we had a case, you've all heard of Miranda. Yes. So, when someone is arrested, or taken into custody, they read their Miranda rights, advised what those are, and they can waive them. So we had a case in 2023 that was assigned to my judge. And this particular case, the defendant was 17 at the time he committed the murders. It was a terrible case, factually speaking. It's a woman and her son, 15-year-old son, owned a bunch of laundromats in this, now I'm going to tell you what city it was, I can't remember. It was in Wayne County. So of course we see murders all over the states, just as manner, there are many. But so they committed this event, they've gone to the laundromat to clean up, pick everything up that night. They're in all the quarters and all. They don't go back home. Husband's worried, calls the police, they're found the next day. They're both nowhere near the laundromat, on the other side of some railroad tracks, they've both been shot in the head. All the money's gone. The van that they drove over there is gone. Next day, they find a group of 4 guys in that van as they pull back into town. So let me just remind you too, that sometimes criminals do not think intelligently. So they can drive right back through town in the van, was not thinking about the fact that they might get busted. So, and then one of them, the defendant in our case, who was 17 at the time, was arrested. He was given the death penalty. When his case came up to our court, this all happened in this case actually was in 1993. We just saw it in 2023 for the second time. So he's convicted in 1993. His case goes up on appeal. Our court affirms it. And he then goes before the habeas courts. Remember, I was also telling you, the motion for new trial, appeal to our court, and then habeas. So the habeas court ends up reversing. Partly on the sentencing, because he was given the death penalty. And at this point in time, the law had changed, so you no longer have to. That just would have been a resentencing issue. But they also found that his trial counsel was ineffective in failing to present some evidence that would have actually been helpful to his case. So he's retried in he's retried in 2014, then takes 6 years for his motion for a trial to be heard. It's very, very long. And in the course of the retrial, there was some evidence that had previously been suppressed by the prior judge in 1993, who's no longer on the bench, 2014. They asked him to revisit it. They revisit it. And the trial judge in the retrial decides, I'm going to allow this evidence in. And it's actually a statement he gave to police confessing that. So it comes before our court. And he raises two issues. One is the trial judge shouldn't have been able to revisit this ruling from the prior case where the judge said this isn't coming in. The other issue was, he said the reason it was suppressed in the first case was because I invoked my right to counsel. And they shouldn't have questioned me when they did. So this was my case with my judge. And she's a prosecutor and she's a prosecutor. You gotta, you kind of have to keep like a spray bottle nearby whenever she starts thinking about something being reversed. She's so bad. So we had this whole discussion about this Miranda case, and this is the interesting thing. This young man, this Mirandized, he's read his rights, gets in the back of the police car at the time they arrest him, not far from the van that he's just brought back into town and is running from the next day. They read his Miranda rights. They start talking to him a little bit, just kind of general discussion of who else was involved, what else happened. And then they get to the police station. And while the officer is just patting him down and asking him some routine booking questions, he says, I'm not saying anything without a lawyer. Then the next day, he's interviewed by some GBI agents. They read him his Miranda rights again. He agrees to waive them. And he lets it all out. Tells him everything that happened. So here's the question. At the time, he said, I'm not talking without a lawyer. Our court had to decide, had he properly invoked his right to counsel, such that they could not question him the next day. And so this was this little Miranda, this Miranda nuance. So you've got someone, he's in custody. But the way Miranda's written is that you have to be in the middle of an investigation. The ones you see on TV where you all have, you've seen firsthand. You have to be actually like in the room with it's a custodial room. You can't go anywhere. You're not allowed to leave. You're being asked questions. This is the context within which if you say, I'm not talking about a lawyer, they have to get up and go and your lawyer can talk to you. But in a booking space where you're just being booked in and just patted down and no one's asking you anything, can you invoke Miranda then? We've never said you couldn't. Well, we end up having a 5-4 score. And that rarely happens. Because 4 of the judges, this will not surprise you that they were all the trial judges, including mine, said he did not invoke his right to counsel. He was free to be interrogated the next day. Because this was just something anticipatory. Like, I'm not talking about a lawyer, but he's not actually being questioned. But the majority, that written by our Chief Justice, Justice Peterson, found that he hadn't. And so we were initially writing the majority. And this happens sometimes, we flipped. So after I had written this whole opinion with my judge's assistants, we then turn around and have to write the dissent. So we have 4 judges on one side, 5 judges. So it's a very, very interesting case for all. And this happens. I mean, I would say in large part, they try to be unanimous. But sometimes, so for example, there used to also be an issue, this case came out in 2021 by Justice Warren. So Justice Warren, Westminster grad, young justice, also a solicitor general, never a judge before she was appointed to the Supreme Court. But she's extremely bright, extremely thorough. She's one of the reasons now, in addition to Justice Navius, who's no longer on our court, but was when I first started. Why, when you go in to argue, you are really probably not going to be doing a whole lot of work. You're going to be asking people a lot of questions. If you come argue before our court now, you would be amazed at how little argument you're actually going to get out before you're going to be asked question after question after question. Justice Ellington, who I referenced earlier, who's the only one who was actually voted onto our court, his position is let the people, I'm just gonna sit here and listen. If I have a question, I'll ask. He never asks. But usually that's what happens. You're getting question after question. You're not really arguing the case law. And so, but she is very thorough, and she's also one of our heavy editors, because when you circulate opinions, the justices will give you edits. This is not something I was prepared for. Having worked for a trial judge, who I would write something for her and work her on a motion for summary judgment or what have you, which she would say, hey, that was good. No. In this space, when you circulate, it's like a bad English paper. I mean, you get it back and there are edits the first time I got edits on one of these, I was like, okay, I think I need to go work at a bookstore, maybe be a barista at a coffee shop. Clearly not how. I've not seen that much blue pen since probably 9th grade. But it happens to everybody, and it's because they want to get it right. You know, I mean, the decisions in our court issues now are so much more thought out. But I have to tell you about a case that in my mind is a little bit funny. So in 2021, there had been this question that came before us whether this is again a criminal case where it used to be that if your trial counsel failed to file your appeal timely for you might remember this, you could file a motion for out of time appeal. Did you ever see that then? Yeah, so motion for out of time appeal, you could file this before the court said, look, my attorney messed up, I didn't get to file my appeal. That was a motion that just sort of was created at what we say sometimes in our court on whole cloth. My justice greatly dislikes that, but it's not way. So it was created and they would let them do it, that was something that happened. Well, in 2021, our court eliminated the motion for out of time appeal and said no. And I filed a motion for out of time appeal. Your only right is a habeas. So if you've not filed your motion for your trial or filed your appeal on your case, whether it's another crime that might go to the Court of Appeals or a murder that might go to us, you're out of luck. Motion for out of time appeal is fine. Her opinion. You see how thick this is? This is what was written to get rid of the motion for out of time. So you're a trial judge, and okay, where does tell me what happens? Okay, let's see, I think I'm there, wait, no, 84 pages. 84 pages. So my judge said, we are writing concurrence that will be 5 pages long. And it's basically gonna say what it says in the majority opinion, but we're gonna say it on the first page. And so we did. And that's where my judge was, she's like, this is something that you said, and listen, let me say this, Justice Warren wrote the majority, and it is as well written and well thought out and researched as possibly be. Because you're getting rid of something important, and it deserves what but it's one of those situations where this is the beauty of having different minds. Because you have also someone to say, I'm gonna go ahead and just slot this in so that when people want to actually figure out what happened, they can just go to the concurrence and say, okay, here it is summarized in 5 pages. So anyway, but how am I on time?
And we're in it, so however long I can.
Okay, so, does anyone have any questions? By the way?
Don't have questions.
Do it. Don't do them now, don't do them, okay, okay, so I talked about murder. How many of you knew that we had that many workplaces? Anyone? Yes. Yeah, so that's it, I mean, it's amazing, actually. And in recent months, there's been a little bit of a push for us to get rid of it. And it's gonna require, it's something that we will address, I think, in the coming year or two, probably. But there have been, the attorney general, so in every murder case, I'm sure this is why. In every murder case, you get a brief from the defendant, the appellant, so his counsel, or her counsel. And then the DA's office will also file a response brief, but the AG's office also has to file. So the attorney general's office has to respond in every murder case. I think they get tired of doing that. And so recently, they actually raised the issue, like whether, I'm not sure, that's not exactly what it is, but they do have to file a response on every murder case. And so they asked us to look back at it. Yes.
Is there some kind of unique perspective that the Attorney General brings to bear on those questions?
Not necessarily, I will say, if you have a weaker district attorney's office, the question was, is there a unique perspective that the AG's office might have? There's not, I will say that they tend to be more thorough. So sometimes you'll have a situation where the DA's office will punt a little bit. So they might say, okay, the Attorney General's office did a really good job with that brief, so we'll just add a few things. Sometimes your DA's office, the DA's office will have a strong response. It just depends. It makes it a little harder when you're the staff attorney having to review all that because they can be duplicative. So as I was saying, what we do for our judges is when we have a case on bank and we've read everything, we're ready to present the case and tell them, we think we should affirm this. Sometimes we think we should reverse, we think we should vacate and remand back to the court, something was missed. We will actually, we have to lay out what all the parties' contentions are. So we'll lay out the facts, we'll lay out the contentions, we'll lay out why we think one way or another. But it's duplicative. I mean, oftentimes we're looking at the same things. But I think it was probably for some of the more rural district attorney's offices who may have a lot of cases to be inundated. We get a fresh perspective from the AG's office. Of course, defense attorneys are also inundated work too. So that's just a given. But they, they have that opportunity. We also, as I mentioned, have a oral argument just about once a month. And we do the same thing for our justices in that instance, only it's all the bench. So we are also presenting them with whatever the pertinent facts are in the case, as well as the parties who are arguing the appeal, and then we will give a recommendation. My judge will decide this is what I think we should do in this case. So one of the most interesting cases we've had in the past few years, if you can believe it, is a case about booting. All right, so do you know what I mean when I'm talking about booting? You've seen some of the paper about this, right? So there was a case we had where there was just this parking lot in DeKalb County. And I think if you read between the lines, which I kind of dug a little bit, I figured it out. It was off the highway. So a lot of tractor trailer drivers would park in this lot and sleep. And there were others who might have parked there too, but it's this movement of, if you're not here for business in one of these businesses, we're gonna boot your car. Right? Now, in the city of Atlanta and some places here, they actually have ordinances that tell you that, and they have to post signage that says, if you park here, we're gonna boot your car. But the fee they might charge you is something like $75, and there's a phone number, and you know who to call, and you know in advance. Well, in this particular case, there was no signage. They were booting cars and charged between $650 to $1,000 to remove the boot. So one person who was booted decided we're filing a class action against this property owner for booting all these different cars. So it goes before, it ends up at our court, because the question was, there were a number of issues that went before the court, the trial court and the Court of Appeals. But the question that we ultimately took the case to decide was, is there a right? I mean, is there a right that, common law right that goes back in time for a private property owner to just immobilize a vehicle that's not authorized to do it? So of course, we have towing. You know, we have things, but to just, but here, it was not knowing how we were gonna go. We had to go all the way back to the 1700s. I remember sitting down with Justice Nanias and saying, okay, we're gonna have to find some cases from 1700s, 1800s to go back to whether this was a right. It turns out, because the parties were arguing, it was back in the days when people like cattle might wander on to adjacent property owners' property. This is where they said the right came, because the person who, you know, the cattle comes on their land and starts eating their, you know, their petunias, and we're messing up their wheat. And so we're just gonna keep the cow. We're gonna keep your cow until you get back over here and pay us for the damage that you've done, and then you can have your cow. Or put up a fence, you know, whatever. So this is what we realize is the origin of booting a car. So the term, you can put this term on distress damage phasons. That is the name of the term from the common law right, distress damage phason is what it was called. I can't believe I'm actually putting a 1700 date in this thing. My judge could not believe she was having to do this, you know. But what we ended up determining was, no, there was no right to do this. Because here, they kept talking about, the property owner kept talking about the damage and the trespass and all that. Like, well, you're actually perpetuating the trespass by booting the car. Right? And you're preventing the car from leaving. And what's your damage? What harm is this vehicle doing by being there? You can't just randomly boot a car and force this person to pay whatever obscene amount you come up with. You know, that's just not right. And so I think actually it was very funny because Justice Nanias got so spun up during World War, about this case. I remember some spitting and him saying something like, well, this is just nuts. That's a big, but so anyway, we wrote it, ended up issuing, well, so now there's actually been some recent laws that have been instituted, and more ordinances are coming out, because of course that's the way to do it. You need to post signs, you need to have ordinances, you need to have a reason that people can pay. So, anyway, but, so we do have some significant cases. Keep an eye out for whether we grant cert in the Fonnie Willis, Trump, et cetera cases. So that case went to, so if you remember, anyone followed the Fonnie Willis disaster with all the Trump and all that? Yes, okay. So, and her conflict of interest. So the trial judge, of course, the defendants moved to dismiss the indictment. And the trial judge said, there's no conflict of interest for the DA's office, because this was the situation where Fonnie Willis and the prosecutor, special prosecutor she hired and was paying to prosecute the case, they were in a relationship and had traveled, done some other things together. So the trial judge said, no conflict of interest, but there is an appearance of impropriety. Okay. So we're not going to remove you. We're going to let you decide, Fonnie Willis, whether you would like to step out and resign and just step out of the case and move the whole DA's office out, or whether he will just resign. Of course, she did not step out and pull the whole DA's office with her, nor would anyone have expected her to do that. And he resigned. So that went to the Court of Appeals. The Court of Appeals reversed the trial. And now they're seeking cert on this question. So stay tuned. Thank you.
Anybody has some questions? I assume you do. Please use the mic. You have a question?
You told us about this practice when this gentleman,
Yes.
the Supreme Court. There should be a move afoot to appoint staff attorneys. And that precedent needs to be set for you.
And
Thank you for wonderful.
Thank you. Well, unfortunately, our staff attorney's politics are usually a little different than the justices, just gonna say that.
Yeah, so I'm not an attorney. But I understood about 75 to 80% of what you said.
That's good.
I didn't think that. And so I have a sort of a naive question to ask. And that is, I am impressed by your account of the enormous amount of research involved in many of these cases. Enormous amount of reading and thinking and referencing and all your experience, blah, blah, blah. Is there a rule or a guideline where the load that you have to carry is limited? Because there could be a point where you're so overburdened that you can't allocate enough time to do the research thoroughly enough on some of these existential cases.
So there's not a rule, but we do have terms. So cases are docketed terms. We have, it's kind of manual, so there are 3 terms a year. And the benefit of that is we actually have roughly a 6-month period from the time a case is docketed until the time it's gonna go out. And so we have time for our cases, even though they do require some more than others, a lot of research, a lot of reading, and a lot of processing. We have enough time to manage them, and because there are 2 staff attorneys plus a term clerk, we can divvy some of that out. So at any point, like for the current term that's coming up, I am assigned to 5 cases, but one of those has already been orally argued, so I already had to do the legwork on it. And one of those I've already gotten in front of the justice. So it is just a time management piece. You have to just keep it moving, but it tends to be fairly good. Now, we are getting more cases because COVID backlog, murder cases in particular, are starting to come. So we do, but it's manageable, happy to say.
John? Libby, thank you for your presentation. I'm curious, it sounds like you and your co-worker and the intern do all the work. What's the Supreme Court judge actually do?
So she does take some. So some judges, some judges are stronger writers than others. I mean, some of them really do like to write. My judge does do some writing. I mean, you're seeing behind the curtain a little bit here. Please don't put this in the paper tomorrow. I'm really just a ghost book. My name goes fine, nothing. Nor do I want it to in your show. But she reads, the justices are responsible for everybody's stuff, not just their own. So they have to read everyone's work and all the cases that are coming in. So one thing I didn't cover, that in addition to all the certs, we might grant a few, but there are, every time we have bank every 2 weeks, there are probably 50 to 70 cert cases they're reviewing to decide whether to grant it or deny it. She has to read all of that. Plus we have habeas. So we are also the appellate court for the habeas. Those often are not, we don't often grant those. We do rule every now and then. It's just more that it's not that there's anything wrong with them, that they're not given, the attention they deserve. And so she's reading everyone's opinions, and she's also getting us notes back and reading the record, so she can have discourse. And she's ultimately the one telling us how we're gonna rule. So she knows the case and has read it. She's just not necessarily doing the writing. She's not sitting there writing, if that makes sense. She just doesn't have time. So.
Let me mention, I know when I was in Judge Magrua's court, and she was in Wolf Superior, she used to bake cookies at Christmas time to give them to the younger criminal defendants who were coming in her court, and she used to assign homework when they would write reports. And I heard a young man talking about how he had done his report, but he left it on the MARTA on his way in, so it didn't have it. He said, well, can you give me the report? Were you with her when that happened?
I was with her, so she had, my judge actually, this is a really thing, she had a probation program called My Journey Matters. And, she would identify certain defendants who might be a good candidate for this, and what she would do is kind of backload their sentence. So instead of them going right to jail, she would give them an opportunity to report once a month, but there were certain things they had to do, like get a job, finish school, they had, get a GED. They had to do book reports, which are always funny, because sometimes you'd be reading a book report and there'd be a word in there. Like, she's like, what is this word? She asked them, what does this word mean? And then, yeah, I don't know. So she, or, because obviously they're probably technical. Now there would probably be AI random. It wasn't even AI. Yeah, so my husband can speak to the cars of that, but yeah, so, I was with her guy, and she was great.
I'd like to have you come back since Judge McBurney wrote the opinion. He's been a speaker here several times. If you and Judge McBurney, after he reviewed his decision ultimately, and write an opinion, we'll get that.
Okay. Done. Done. Thank you so much.